Okay. Are we ready to proceed? And you wanted me to read this instruction before you gave your opening.
It needs to be read before we introduce the evidence. I don't know what Mr. Arnold's preference is as to whether it's read before opening.
It can be done with your introductory remarks, Your Honor. If you're reading instructions, because it is going to be introduced, like we said, probably off of the first witness. And so we don't want to take the time then to go ahead and, do the Travis instruction.
Okay. Okay, I'm going to go ahead and let's go ahead and bring the jury in, and I will read it right after I finish my instructions before they get up to do their opening. Okay?
Thank you, Your Honor.
I'll press it, Your Honor.
Will counsel please stipulate to the presence of the jury?
Yes, Your Honor.
Defense
Right.
does.
You may be seated.
Guys, at the end of the day, we should just let you know.
Okay. Okay, ladies and gentlemen, you are admonished. No juror may declare to a fellow juror any fact relating to this case as of his or her own knowledge. And if any juror discovers during the trial or after the jury has retired that he, she, or any other juror has personal knowledge of any fact in controversy in this case, he or she shall disclose such situation to me through Officer Black in the absence of the other jurors. This means that if you learn during the course of this trial you were acquainted with the facts of this case or the witnesses and you have not previously told me of this relationship, you must then declare that fact to me. During the course of the trial, the lawyers for both sides are not permitted to converse with members of the jury. These individuals are not being antisocial. They are bound by ethics and the law not to talk to you. To do so might contaminate your verdict. You are admonished additionally, you are not to visit the scene of any of the acts or occurrences made mention of during this trial unless specifically directed to do so by the court. What that also means, when I say no investigations or to visit the scene, I mean you don't just not do it physically. You don't do it by using your handheld devices, your iPads, your phones. You don't Google Earth. You don't do any of those kinds of things. Everything you are going to learn about, you're going to learn about within this courtroom. Ladies and gentlemen, what I will now say is intended to serve as an introduction to the trial of this case. It is not a substitute for the detailed instructions on the law, which I will give you at the close of this case and before you retire to consider your verdict. This is a criminal case commenced by the state of Nevada, which I may sometimes refer to as the state or the plaintiff, against the defendant, Mr. Redden. The case is based upon an indictment. At this time, actually a second amended indictment. The clerk will now read the second amended indictment to the ladies and gentlemen of the jury and state the plea of the defendant to that second amended indictment.
District Court, Clark County, Nevada, the State of Nevada plaintiff versus Deobra Redden, defendant, case number C24380-558-1, Department 22, second amended indictment, State of Nevada, County of Clark, the defendant above named, Deobra Redden, accused by the Clark County Grand Jury of the crime of attempt murder, victim 60 years of age or older, committed at and within the County of Clark, State of Nevada, on or about the 3rd day of January 2024 as follows. Count 1, attempt murder, victim 60 years of age or older, did willfully, unlawfully, feloniously, and with malice aforethought attempt to kill Judge Mary K. Holthus, who is 60 years of age or older, to wit, during rendition of sentence, and once he knew she was about to sentence him to prison, did leap over defense counsel table into the well of the courtroom, thereafter rushing towards the judicial bench and jumping over it Superman style directly into Judge Mary K. Holthus's judicial space, landing directly on top of her and immediately attacking Judge Mary K. Holthus by grabbing her, pulling her hair, placing his hands around her throat, and or hitting her on the head by manner and means unknown. Dated this 3rd day of September 2024, Stephen B. Wolfson, Clark County District Attorney, by Elizabeth Mercer, Chief Deputy District Attorney, to which the defendant has pled not guilty to.
Please understand that the second amended indictment is simply a charge, and it is not in any sense evidence of the allegations it contains. The defendant has pled not guilty to the second amended indictment. The state, therefore, has the burden of proving each of the essential elements of the indictment beyond a reasonable doubt. As the defendant sits there now, he is not guilty. The purpose of this trial is to determine whether the state will meet that burden. The trial will proceed in the following order. 1, the parties have the opportunity to make opening statements. What is said in opening statement is not evidence. The statements simply serve the purpose of an introduction to the evidence which the party making the statement intends to produce. 2, the state will introduce evidence in support of the indictment. This is called the plaintiff's or the state's case in chief. After the state presents evidence, the defendant may present evidence, but is not obligated to do so. This is the defendant's case in chief. If the defendant presents evidence, the state may present rebuttal evidence. 5, if the state presents rebuttal evidence, the defendant may present surrebuttal evidence. 6, after the evidence, I will instruct you on the applicable law. You must not be concerned with the wisdom of any rule of law stated in these instructions or in the instructions which I will read to you after the evidence, regardless of any opinion you may have as to what the law ought to be. It would be a violation of your oath to base a verdict upon any other view of the law than that given you by me. 7, after the instructions on the law are read to you, each party has the opportunity to present closing argument in support of their case. What is said in closing argument is not evidence, just as what is said in opening statements is not evidence. The arguments are designed to present to you the contentions of the parties as to what the evidence has shown and what inferences may be drawn from the evidence. Your purpose as jurors is to find and determine the facts. Under our system of criminal procedure, you are the sole judge of the facts. You determine the facts from the testimony you hear and the other evidence, including exhibits introduced in court. It is up to you to determine the inferences which you feel may be properly drawn from the evidence. It is especially important you perform your duty of determining the facts diligently and conscientiously, for ordinarily there is no means of correcting an erroneous determination of facts by the jury. The parties may sometimes present objections to some of the testimony or other evidence. It is the duty of a lawyer to object to evidence which he or she believes may not properly be offered, and you should not be prejudiced in any way against the lawyer who makes objections on behalf of the party he or she represents. At times, I may sustain objections or direct you disregard certain testimony or exhibits. You must not consider any evidence to which an objection has been sustained or which I have instructed you to disregard. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Remember, statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorneys stipulate or agree as to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuation suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must not be influenced in any degree by any personal feeling of sympathy for or prejudice against the state or defendant. Both sides are entitled to the same fair and impartial consideration. In considering the weight and value of the testimony of any witness, you may take into consideration the appearance, attitude, and behavior of the witness, the interest of the witness in the outcome of the case, if any, the relation of the witness to the defendant or state, the inclination of the witness to speak truthfully or not, and the probability or improbability of the witness's statements and all of the facts and circumstances in evidence. Thus, you may give the testimony of any witness just such weight and value as you believe the testimony of the witness is entitled to receive. There are two kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what that witness personally saw, heard, or did. Circumstantial evidence is testimony or exhibits which are proof of a particular fact from which, if proven, you may infer the existence of a second fact. And I'm going to give you an example of both. You know, it's been pretty hot out there, and I understand it's going to get hotter probably in the next several days before it starts cooling off. I want to take you up to Mount Charleston in the middle of winter, okay? I'm going to take you up there in the evening, and it has just snowed, and you see this beautiful blanket of undisturbed snow. Now, it's pretty well lit because we've got a full moon up there. So you've got the full moon, you got this beautiful blanket of undisturbed snow among the trees, and as you're looking at the scene, you happen to see a bunny hop through the snow. That is direct evidence that the bunny was there. You saw it. You saw the bunny hop through the snow. Okay, I'm going to take you back. Full moon, dark sky, shining on this beautiful scene, except there's one difference. The snow is not totally undisturbed. There are bunny tracks already in the snow. You didn't see the bunny there, but it's fresh tracks. You can infer that is circumstantial evidence that the bunny was there. Okay? You may consider both direct and circumstantial evidence in deciding this case. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any evidence. No statement, ruling, remark, or comment which I may make during the course of this trial is intended to indicate my opinion as to how you should decide the case or to influence you in any way in your determination of the facts. At times, I may even ask questions of witnesses. If I do so, it is for the purpose of bringing out matters which I feel should be brought out and not in any way to indicate my opinion about the facts or to indicate the weight I feel you should give to the testimony of the witness. I may also find it necessary to admonish the lawyers. And if I do, you should not show prejudice or against the lawyer or his or her client because I found it necessary to admonish him or her. Until this case is submitted to you, you must not discuss it with anyone, even with your fellow jurors. After it is submitted to you, you must discuss it only in the jury room with your fellow jurors. It is important that you keep an open mind and not decide any issue in the case until the entire case has been submitted to you under instructions from me. If you cannot hear a witness, please raise your hand as an indication. I might note we do have earmuffs that can amplify the sound if you are having problems hearing. And the only thing I ask that you do is that when we're not in session, whenever I'm talking to the lawyers privately under the white noise, I'm going to want you to take it off, because literally you're going to be able to hear what's going on the tables of the lawyers, and you're going to be able to hear what's going on up here, and you're not supposed to hear that part, okay? Also, I plan to have regular bathroom breaks about every hour and a half or so. I try and peg it so I'm not interrupting witnesses or so forth, but sometimes I may do that. So I'll time it to be right in the middle of the session. But I do appreciate nature calls sometimes, and you just really got to go. Just raise your hand as an indication, and we'll go ahead and take a break right there. Okay? I may during the trial take notes of a witness's testimony. You're not to make any inference from that action. I am required to prepare for legal arguments of counsel during this trial, and for that reason I may take notes. Again, let me remind you that until this case is submitted to you, 1, do not talk to each other or anyone else about it or about anyone who has anything to do with it until the end of the case when you go to the jury room to decide upon your verdict. 2, anyone else means members of your family and your friends. You may tell them you are a juror in a criminal case, but don't tell them anything else about it until after you've been discharged as jurors by me. 3, do not let anyone talk to you about the case or about anyone who has anything to do with it. If someone should try to talk to you, please report it immediately through Officer Black. 4, do not read any news stories or articles or listen to any radio or television reports about the case or about anyone who has anything to do with it. And again, that means you don't use your handheld devices to check me out or the lawyers out on Facebook or anything like that. Everything you will learn about this case, you're going to learn inside this courtroom. A trial is a search for the truth under the rules of law. Therefore, the court will allow members of the jury to ask written questions of any witness called to testify in this case. You are not encouraged to ask questions because that is the responsibility of the lawyers. Nevertheless, if you believe that an important question has not been asked or that an answer needs clarification, you may submit a question. Keep in mind, a witness scheduled to testify later in the trial may be the best person to answer that question. A question may be asked in the following manner. Please write it down and pass the paper to Officer Black. Make sure your juror number is on that piece of paper. Copies will then immediately be made for counsel and me as the presiding judge. I will then privately confer with the lawyers at a convenient time and then decide if the question is appropriate under Nevada law. Also, when you submit a question, make sure that you are submitting it while we are taking in the evidence. That is, when the witnesses are testifying and the exhibits are being admitted. If you start asking the questions during opening statement, we can't help you there. And most certainly during closing argument, we will not be able to open up the evidence to have that question answered. Okay? If the question seeks factual information from the witness and is designed to clarify information about the issues in this trial, I, the presiding judge, or the lawyers may question the witness regarding the points raised in the juror question. No emphasis should be placed on the answer to the question merely because the question came from a juror. If a question submitted by a juror is not asked, no adverse inference can be drawn. The question was simply not allowed under the Nevada rules of evidence and must be disregarded. Would the either of the parties want the exclusionary rule invoked?
Yes, Your Honor.
Yes, Your Honor.
Okay. If there is anyone present who expects to be called as a witness, please leave the room. Remain available in the hallway and do not discuss your testimony or the testimony of any other witness with anyone except the parties to this lawsuit and their lawyers. Okay? And counsel, do you have any, we talked about the admissibility of exhibits before. I'm going to go ahead and the parties have stipulated to the admission of certain exhibits. That's just to save us some time so they don't have to lay the foundation for it. States exhibits 1 through 33 and 40 through 61 are admitted. Okay? And I have an instruction to give you. Any evidence that the defendant committed offenses other than that for which he is on trial, if believed, may not be considered by you to prove that he is a person of bad character or to prove that he has a disposition to commit crimes. Such evidence was received to provide context to the events upon which the charge is based, and because it was not possible to omit other relevant evidence and at the same time exclude evidence of other crimes. Should we mark that as court's instruction number A?
Yes, Your Honor.
Are you okay with that, Mr. Arnold?
Yes, Your Honor.
Okay. All right, counsel.
Thank you, Your Honor. Do you have your microphone on? I'm about to turn it on right now.
Okay, thank you.
I tried to kill a judge today. Those were the defendant's words mere hours after he violently attacked Judge Mary Kay Holthus in this courthouse on January 3rd of 2024 in courtroom 3F.
In accordance with the laws of the state of Nevada.
Is she okay? Hey. Hey, can you fucking radio somebody? Fucking radio somebody!
We're all here today because of that attack. Judge Mary Kay Holthus is here today because of the bravery and intervention of 6 men. Her law clerk, Michael Lasso, Correctional Officer Joseph Cabralda, Chief Deputy District Attorney Jory Scarborough, Chief Deputy District Attorney Richard Scow, Marshal Shane Brandon, the court marshal in Department 18 where this event occurred, and Marshal Ben Bachhuber, who is the court marshal in the courtroom next door. On the date of this incident, Judge Mary Kay Holthus was 62 years of age. She had been a judge since 2019. She had a mixed caseload, which meant she heard both civil matters and criminal matters. January 3rd of 2024 was a Wednesday, which meant it was a criminal calendar day. In anticipation of her calendar, she went through her calendar before the calendar actually occurred. Mr. Redden's case was obviously on calendar that day. She reviewed the relevant information pertinent to Mr. Redden's matter, which was on calendar for a motion to quash bench warrant and rendition of sentence, meaning he was supposed to be sentenced in front of her. The information she reviewed consisted of his pre-sentence investigation report. That report provides her important background information about Mr. Redden, but also the facts of the underlying offense. She made some preliminary notes. There was nothing particularly unique about Mr. Redden's case. Then her criminal calendar occurs. When Mr. Redden's case gets called, it's approximately 11:10 in the morning. A little more than halfway through her calendar, which began at 9:30 a.m. When the case gets called, initially, everything is going normal. You'll hear that typically with criminal sentencing, the state gets to argue first. Then a defendant is free to make a statement if he wishes to. In this case, Mr. Redden did. He argued for probation. He presented the court with information that he believed mitigated against a term of incarceration. After Mr. Redden was done, his defense attorney, Cesar Almasi, also made an argument to the court, seeking probation on his behalf. After Mr. Almasi was done, but prior to Judge Mary Kay Holthus having the opportunity to impose the sentence that she believed was appropriate, she made a comment, and that comment was interpreted by many people in the courtroom, including Mr. Redden, as indicating that he was not going to receive probation. After that comment was made, and before she imposed the sentence, Mr. Redden jumped over defense counsel's table, which was approximately 2.5 feet tall and 3 feet deep. He then bolted towards Judge Mary Kay Holthus' judicial bench. As you can see from this picture, the courtroom is set up differently from how this courtroom is set up. There's only one entrance and exit to the judicial bench in that courtroom. He then launched himself 4 feet, more than 4 feet, in the air, and tackled Judge Mary Kay Holthus like she was a football player. He then, once was over the bench and made contact with her, pulled her by the hair as hard as he could, and yanked her to the ground like she was a rag doll. When she testifies, you'll hear that she remembers being struck in the head, but she doesn't remember how it happened. She doesn't remember if it was an intentional act by the defendant, whether her head hit something, an object nearby during this altercation. But she remembers being jolted and frightened. She was trapped. This is the judicial bench in that courtroom. That entrance is the only entrance to or from where she sits when she presides over her calendar. And the altercation that you saw in the first clip happened right there. She had nowhere to go. She was terrified. She knew that she was no match for his physical strength. So she hid. She hid as far away from Mr. Redden as she possibly could. She crawled into the corner of that bench and waited there until the entire thing was over. When you watch the full video, you'll see that it took approximately 3 to 4 minutes before Mr. Redden was moved from that location. She was so shaken up, you'll hear, that initially she tried to climb that wall that you see in the picture and exit her courtroom where her court clerk sits. That's not an exit. But she did not want to be near Mr. Redden, and Mr. Redden was still in the entrance when he was eventually apprehended. Michael Lasso was the first person to intervene on her behalf because he was situated closest. Michael Lasso is her law clerk. He's been her law clerk for several months now. He'll tell you about what his job duties are as a law clerk. But more than a law clerk, he is also a close family friend of the Holthuses. He has known Judge Mary Kay Holthus his entire life. He was not supposed to be at work that day. Fortunately, he changed his mind and decided to go in. He will tell you that among his many job duties as his law clerk, or as her law clerk, is he sits next to her during the calendars in case something comes up that she needs help with. Thankfully, on this day, he was situated exactly where he needed to be, to her left in that courtroom, as she presided over criminal matters. He was answering emails, performing work, and also paying attention to what was occurring on the calendar. He first realized that something was amiss when Judge Holthus made a comment and her marshal moved closer to Mr. Redden. You will hear that when her court marshal moves closer to a defendant who appears out of custody for sentencing, that generally means that defendant is about to be remanded into custody. When the marshal moved closer to Mr. Redden and started to unclasp his handcuffs, they jingled. And then he remembers seeing Mr. Redden bolt over defense counsel's table and across the courtroom. Initially, he believed that perhaps Mr. Redden was trying to exit out of one of these rear exits in the courtroom that staff use. But it became apparent to him pretty quickly that his intended target was Judge Mary Kay Holthus. And when you watch the video, you'll see the surprise, the shock in his eyes as he's watching this occur. He remembers Mr. Redden launching himself directly at Judge Holthus and knocking her out of her chair with such force that her head hit the tile wall behind the bench. He immediately knew that he needed to take action because he was frightened for her life and he was frightened for his own life. So he lifts Mr. Redden off of Mary Kay Holthus because he's the closest person to her. He got some assistance along the way, and the first person to come to his aid, and Judge Holthus's aid, was Correctional Officer Joseph Giralda. You will hear that on this date, he was assigned to the Field Services Unit at the Clark County Detention Center. That means that he's one of the correctional officers that's responsible for transporting inmates to and from their court hearings. He's also responsible for documenting the outcome of those hearings. So he was seated in the witness stand in that courtroom, which is directly next to the judge, but there's no doorway between the witness stand and the judge's bench. So when he saw the defendant go for Judge Mary Kay Holthus and tackle her, he had to climb over that wall to get to the point where he could assist. When you watch the video where the yellow circle is, that's Officer Cabralda climbing over the wall. At this time, Officer Cabralda was the only correctional officer remaining in the courtroom because other correctional officers had just done what they call a download, which means moving defendants who are already done with their cases back to the detention center. You will hear that he struggled mightily trying to get control over Mr. Redden. That Mr. Redden resisted both he and Mr. Lasso and everyone else that came to their aid very hard. At some point, Mr. Redden was able to knock him to the ground. At which point, Mr. Lasso and Mr. Scarborough began to work even harder to get him off of Officer Cabralda, because Officer Cabralda was armed that day, which could have presented a whole new set of problems. Mr. Redden continued to resist, which is why you see Officer Cabralda and Officer Lasso striking him over and over again, because they needed to get him to comply, and he was not getting it. He was still struggling to get away from them, struggling to get back to Judge Holthus. Eventually, they do get him under control, and Officer Cabralda actually uses one of Marshal Shane Brandon's, his actual set of handcuffs. He gets one cuff on Mr. Redden, but Mr. Redden is still resisting, so it takes an additional marshal before they can actually get him into both arms into the cuffs. Chief Deputy District Attorney Jory Scarborough was in the courtroom that day because he had another matter that was on calendar, not Mr. Redden's case. He's assigned to a specialty unit at the Clark County DA's office, the gun crimes unit. And you'll hear that as a specialty team deputy, he makes multiple court appearances in a day, oftentimes. So he arrived at Judge Holthus's department at around 10 a.m. and he was still present, waiting for his case to be called when this broke out. Again, he was partially paying attention, partially not, but he got the gist that Mr. Redden's case was on for sentencing. The state wanted prison time. Mr. Redden wanted probation. And then he figured out that Judge Holthus was not going to give him probation. He remembers, like Mr. Lasso, watching Marshal Shane Brannon move closer to the defendant. He looks down to do something else. And when he looks up, he sees that the defendant has already cleared defense counsel's table and is running full speed and hurling himself at Judge Mary Kay Holthus. Like Mr. Lasso and Officer Cabralda, he immediately knew that he needed to assist. So he went around the witness stand, climbed over the same wall that Officer Cabralda climbed over, and tried to wrap his elbow around Mr. Redden's neck to gain compliance. It obviously didn't work initially. He'll tell you that Mr. Redden was elbowing him repeatedly and trying to buck him off so that he could get back to Judge Holthus. But with the assistance of Chief Deputy Richard Scow and the other people who I've already mentioned, they were ultimately able to get him to comply. You will hear from both Michael Lasso and Jory Scarborough that once Mr. Redden was under control, their first thought was to check on Judge Holthus. When they checked on her, they saw her still curled up in the fetal position underneath her bench. And she looked terrified. She was frightened, disoriented, shaken. And that really struck Mr. Lasso because he's known Miss Holthus his whole life. And he's always thought of her as a tough cookie. But in that moment, she was scared. Marshal Shane Brannon, as I mentioned earlier, is assigned to Department 18. He's been assigned to that department for approximately 2 years. As the court marshal, he is responsible for maintaining order and safety in the courtroom during calendars. Because of a previous incident that he had where an out-of-custody defendant tried to flee from the courtroom, it became his practice to stand exactly there. The doors behind him that you see in this photograph are the public entrance and exit doors. So he stands there to prevent defendants from fleeing the courtroom if they don't like the outcome. Like Mr. Lasso and Mr. Scarborough, he realized that Judge Holthus was not going to give Mr. Redden probation. So he made his way directly behind Mr. Redden, at which point he intended to handcuff him to remand him into custody. He unclasped his handcuffs, and immediately Mr. Redden bolted across defense counsel table. When you watch the video, you'll see that Mr. Redden hops the table, but Court Marshal Shane Brannon walked around this device that was kind of blocking his path to Judge Holthus. It's called an Elmo. And in his pursuit of Mr. Redden, just as he was about to grab his legs, as he was lunging over the bench, he tripped or somehow fell. And when he fell, he sustained a huge gash to his forehead that required 25 stitches. In addition to that gash, he severely injured his shoulder. He didn't initially notice that his shoulder was injured until he stood up in front of Judge Holthus's bench and tried to propel himself over the bench using his arm. At that point, he realized there was something severely wrong with his arm. He had to have shoulder surgery and was placed on light duty until just a few weeks ago, when he returned to full duty. He doesn't remember a whole lot of the incident, not surprising. But when he stood up and realized what was transpiring, even after he couldn't get over the bench because of his injured arm, he walked around the desk where court staff sits to assist as best he could, given the circumstances. He passed his handcuffs off to Officer Cabraldo and helped try to restrain Mr. Redden. Eventually, court staff in Department 18 alerted the marshal next door to the emergent situation that was occurring in Department 18. He is the court marshal assigned to courtroom 3E, which is directly to the left of Department 3F, which is where Judge Holthus's courtroom is. Court staff walked into the courtroom. They were in session, just like Judge Holthus, and said, "We need you now. It's an emergency. Please come now." So he walked out one of the rear exits to the courtroom like that, and then walked into the rear exit of the courtroom where these events were unfolding. When he walked in, his entrance into the judge's bench area was blocked because her chair, the law clerk's chair, had all kind of piled up right there. He moved them, and when he got to Mr. Redden had one handcuff in the cuffs and one still loose. He was still resisting very hard, and they were struggling to get the cuffs on him. So he took control of the loose arm so that the other individuals could get him in handcuffs. Once the defendant, Mr. Redden, finally calmed down to the point where they felt comfortable relocating him, he was taken to the holding cell just to the side of where the court staff sits. And once he was in the holding cell, Marshal Bachhuber and the other marshals that were down there at this point did what they needed to do to document what had occurred in the courtroom. I think it's the blue jeans, Your Honor. I think it's somebody on blue jeans.
What?
I think it's someone on blue jeans.
Oh, it's somebody on blue jeans. Can you mute them? Oh, God. What? What?
Somebody cut some inappropriate video on there. It was inappropriate.
Okay, we may not be doing blue jeans or Zoom during the hearing, if that's going to happen.
Yeah.
Okay, I'm sorry, counsel.
It's okay.
And I'm sorry. This has never happened. At least not while I've been on the bench.
It was the first time for everything. Anyways, going back to where I was, Mr. Redden sat in the holding cell outside of the courtroom for approximately an hour or so before Marshal Bachhuber, Marshal Rawlinson, and their lieutenant escorted him to the Clark County Detention Center. You'll hear that it's the court marshal's responsibility to book an out-of-custody inmate who was remanded into custody, which is why they had to do it. So they walked him over to the Clark County Detention Center, where he began the booking process. You will hear from Correctional Officer Darren Needham and Correctional Officer Elmis Cabrera that during the booking process, an inmate sees both psych and classification. And that's done for the purposes of determining where to house these individuals. When Mr. Redden was seen by psych on January 3rd of 2024, he reported homicidal ideations. Specifically, the report indicates, in regards to homicidal ideation, patient stated, "Only the judge. She sentenced me to prison." He denied having a plan to harm her. He also denied thoughts or intent to harm officers or other patients, or anyone other than the judge who sent him to prison. Ultimately, because of his expression of homicidal ideations, they determined it would be best to house him in Unit 2C. You will hear that Unit 2C is the unit where they send people with homicidal ideations, among other things. But with regards to his classification in 2C, it was because of his statements. So Officers Darren Meekum and Thomas Cabrera went to transfer release, where the defendant had been waiting for classification. They were tasked with the responsibility of getting him dressed out into his Clark County Detention Center uniform, as well as performing what they refer to as a strip search. You'll see the video of them in the area, but there's no audio. Officer Darren Meacham is the taller individual standing at the front. Officer Cabrera is the individual off to his left. And when they walked into the cell, it was a single person cell. He was by himself. They observed him casually laying on the bench with his hands behind his head. They gave him commands, told him what they were there for, and he spontaneously stated to them, "Sorry I'm moving so slow. I'm kind of sore today. I tried to kill a judge." Those statements that Mr. Redden made and that violent attack against 62-year-old Judge Mary Kay Holthus are the reason that we're all here today. And when the state is done presenting its evidence, we are going to ask that you return a verdict of guilty as to the only charge in this case. Thank you, Your Honor.
Mr. Arnold.
Thank you, Your Honor.
Do you want me to get back on Zoom or no?
Not right now. I want to make sure his presentation's unobstructed. Okay.
We're good. Sir?
May it please the court, counsel, ladies and gentlemen of the jury, thank you for your time and attention. 3.7 seconds. 3.7 seconds. That was when the officer unclaps the handcuffs. My client heard it, turned and looked at him, and made a move for the bench. This all occurred in 3.7 seconds. That was not enough time for Mr. Redden to formulate the intent to kill Judge Holthus. Remember what this case is about. There is one count of attempted murder. And for there to be an attempted murder, there has to be intent to kill. As everything else in life, the story didn't begin on January 13th. This story actually occurred on April 13th, 2023. This is when Mr. Redden was first arrested for what brought him in front of Judge Holthus. And basically, Mr. Redden was arrested for swinging a metal baseball bat at his brother-in-law. What was he charged with? He was charged with assault with a deadly weapon. He was also apprehended by the police, and he was taken into custody. When you're taken into custody, you're supposed to, within 48 hours, stand before a magistrate so they could decide the question of bail or not. Mr. Redden, on April 13th, told the officers that had him in custody that he refused to be transported. So he was just going to stay in custody without these charges being read to him. following week, they waited some time, continued the matter. On April 20th, 2023, Mr. Redden, he failed to leave his jail cell again, and he says that he wasn't coming to the hearing. They had to continue the hearing. Again, on April 25th, Mr. Redden refused to be transported to the heading. Finally, the Justice Court Judge Jacinto, he did an order that says, by any means necessary, he needs to be present in this courtroom. So on April 26th, the officers got Mr. Redden, and he was present. The judge then, he's handed the charges. The judge asked him if he understood the charges. Mr. Redden didn't even respond to the judge's questions, even though he had a copy of the information, which was assault with a deadly weapon, on his person. And not only did he not answer the judge's questions, he became disruptive in the court proceedings. At this point, again, we have almost a week plus that we see this individual not coming to court. Once he gets to court, he's being disruptive and he's not participating in the court proceedings. At this point, his attorney, which was a public defender, then petitions the court to send him to what's called competency court. Competency court is a whole nother courtroom here in our building. And competency court is for people that do not understand the legal proceedings, are unable to assist their attorneys in their defense, or number 3, appear to have some kind of mental condition that prohibits them from acting properly in court. All those things were exhibited by my client, Mr. Redden. He was sent there to be evaluated and see if he can be restored to competency. Restored to competency is basically, we can't try you. We cannot prosecute you under the law since you're not understanding what's going on. You're not displaying courtroom behavior, you're not helping your attorney out. We can't sit here and prosecute you. Go ahead. So, basically, he's found on May 23rd, he's sent to Lake Crossing. Lake Crossing is a mental institution here in town, and what they do at Lake Crossing is make sure that you're evaluated to test your competency. Sometimes, people are sent there and they have lingering symptoms like they're just making up, acting crazy. Other times, they sit there and evaluate someone and their mental instability is so severe, they just have to stay at Lakes Crossing for an indefinite amount of time because, again, the state can't prosecute you under that incompetency. So, in regards to Mr. Redden, he was evaluated and it was determined by Dr. John Paglini, who will be here and he will testify in regards to this case and in regards to his finding of incompetency. And there are other psychiatrists because there at least has to be 2 that make that determination. And what they determined was he was incompetent to stand trial, and so he was given a course of medication because his evaluation indicated that during this course of medication that would calm him down, bring him back to earth, bring him to a person that we can work with, that he can go to court, he can understand the proceedings, and not be disruptive in court. So Mr. Redden, when you go back to that one, I just want to make the last point that he was at Lakes Crossing for 5 months. He was eventually found by the doctors on October 20th, 2023 to be competent to go ahead and proceed with trial. So exactly 5 months later. Go ahead now, sir. After he returned back to Justice Court, he was in front of Judge Jacinto. He had discussions with his attorney at that time, and they decided that he was going to go ahead and enter into a guilty plea with the state of Nevada. Again, now he's of right mind. He is able to discuss his case with his attorney. As you can see, there was no courtroom outbursts or anything like that. And so much so, the judge released him on November 1st, 2023. He was released from custody. Okay? He returns to back to court, and now this is district court. This is in front of Judge Holthus. And on December 6th, he has no extreme courtroom behavior. He goes ahead and the guilty plea agreement's read to him. He answers a myriad of questions, and he pleads guilty to an attempt assault with a deadly weapon. The sentencing was scheduled for January 3rd, 2024. Next slide. What you're going to see through medical records, through the testimony of Dr. Paglini, Mr. Redden did not receive his medication that he had while he was here in Clark County Detention Center. What happened was he gets released and he's given a prescription. That prescription is supposed to be filled at the Mojave Health Center. He calls and you'll hear testimony from Karen Springer. Karen Springer is his foster mother that he stayed with during this time. They made several attempts at appointments, called, and attempted to get him in so he could take his medication. However, you'll see through the testimony, he does not get medication, and he doesn't get it for 2 months. So from November 1st to 2020, in November 1st, 2023 to January 3rd, 2024, a period of 60 days, he does not have his medication. That put him in that state where we saw the appropriate behavior. What you're seeing today, basically, he's under that medication that he had when he was in CCDC. And that's why he's displaying, good decorum, appropriate courtroom behavior. He's not going to wild out, and trust me, I'll tackle him if he tries to, do anything like that. But bottom line, that's not going to happen because he's medicated, he's calm, he understands what the proceedings are and what's going on right now. During this 60 days, Mr. Redden slipped back into his unstable mental state. The same mental state that he had when he was first arrested for assault with a deadly weapon and charged and eventually pled to attempted assault with a deadly weapon. Next. Then we have this unfortunate incident that happened on January 3rd, 2024. One thing I noticed, and I looked at this videotape several times from the very beginning to the very end. I know that all the parties involved. A simple question wasn't asked. And I'll explain later as to why it wasn't asked. But no one asked Mr. Redden, did you take your medication today? His attorney didn't ask, the prosecution didn't ask, nor Judge Holthus asked. I'm not saying this is anybody's fault. It simply wasn't done. So he comes into court and nobody knows what his real mental state is during that time. Nobody knows that for 60 days he's been having paranoid thoughts. Nobody knows that he's been staying at home, not going out into the public, and different other things that were discovered by Dr. Paglini that he'll discuss. Mr. Redden did not intend to kill Judge Holthus. The evidence will show that Judge Holthus, she hurt her head when she struck the wall that was directly behind her, similar to this wall. She also was hurt when she fell on the floor. You'll see pictures. She wasn't significantly bruised. She was bruised, but it wasn't significant bruises. And those were basically on the areas where she fell. She had no cut. She had no strangulation marks on her throat. There will be no evidence that anybody ever that saw Mr. Redden touch her throat. We'll have specific evidence of where his hands were placed right before he was pulled off of Judge Holthus. But again, his actions do not indicate that he was intending to kill Judge Holthus. And again, you always have to go back to intent. That is going to be the big question that you guys are going to have to deal with at closing. Did he have the intent to go ahead and kill? And we are going to submit that the evidence does not show there was any intent to kill Judge Holthus. Thank you.
Okay. Council approach. Okay, ladies and gentlemen, the attorneys were, let's say, a lot more efficient than we anticipated. So we're going to go ahead and finish for the day. I need you back here at 1 o'clock. And remember, you're all like brides. We cannot get started until every one of you are here. So during this period of time, you are all admonished not to talk or converse among yourselves or with anyone else on any subject related to the trial. You're not to read, watch, or listen to any report of or commentary on the trial by any medium of information, including without limitation newspapers, television, the internet, and radio, or form or express any opinion on any subject related to the trial until the case is finally submitted to you. And again, no outside experiments, no visiting the scenes of any of the events that you've heard talked about. Don't use your iPads to find out information about this case. Don't read the newspapers. Everything you will learn about in this courtroom. Have a good evening, and we will see you tomorrow at 1 o'clock.
All right, I'm collecting the notebooks in this room.
has left the courtroom, and you may be seated. Norma, what exactly, do you know what happened?
I don't know what happened, but when I switched to Zoom, there was a very improper video.
Okay. Counsel, I mean, I want to be able to give the public access to the Zoom and all that. I'm just not, we've called IT about this?
I reported it, yes.
Okay. Never had this happen before, but apparently something very inappropriate went on the Zoom system. We cannot have that. And so anybody that wants to see this, definitely you might want to consider being inside the courtroom for that. And then we'll see what we can do on our end so it doesn't happen again. And I apologize again to you for that interruption.
Just for the record, at no point was that broadcast visually to the jury. Although it was audible, we couldn't really tell what it was, in my opinion. But visually, it was not in any way broadcast to the jury.
Yeah, I didn't think that it was either. So, no, she was the only one. I didn't see it on any of my screens.
Yeah, it only came up on Zoom, which I only had access to it. Yeah.
Okay. All right, but anyway, we will try and find out what happened there. Okay. Okay, schedule, 1 o'clock tomorrow. We'll have a full day on Friday, half a day on Monday, half a day Tuesday, half a day Wednesday, if we get into Wednesday. Okay?
Thank you, Your Honor.
And start thinking about those jury instructions. Of course, the most important document is the verdict form that we will need to get through. If you guys could agree to as many jury instructions as possible, that will make our life a lot easier. Okay? Anything else that we need to take care of?
I don't think so, Your Honor.
Okay? All right. Have a good evening.
Thank you.
Thank you.